Welcome everyone. Today we will explore the strategic differences between two forms of intellectual property protection, patents and utility models. We'll discuss their legal foundations, advantages, limitations, and strategic applications. Understanding both options is essential for selecting the most appropriate protection mechanism for your invention. What is a patent? A patent grants the inventor an exclusive right to a technical invention. To be patentable, the invention must demonstrate novelty, involve an inventive step, and be industrially applicable. Patents offer strong legal protection, but come with higher costs and a longer examination process, typically taking several years to grant. Let us compare and summarize the legal requirements for both systems. Patents demand a high inventive step and undergo a substantive examination, making them suitable for complex inventions. Utility models require only formal checks by the patent offices, and they often exclude methods or processes from protection. Thus, the choice depends on the nature of the invention and strategic needs. This slide summarizes the legal requirements for both systems. Patents demand a high inventive step and undergo a substantive examination, making them suitable for complex inventions. Utility models require only formal checks and often exclude methods or processes from protection. Thus, the choice depends on the nature of the invention and strategic needs. Let us now compare their durations, granting timelines and costs. Patents can last up to 20 years but may take 2 to 4 years to grant, and are relatively expensive. Consider costs of more than €10,000 until grant. Utility models last 6 to maximum 10 years. They can be granted in a matter of weeks or months, and they are generally cheaper. Consider costs of up to €10,000. More likely around €4,000 to €8,000. This makes utility models attractive for rapid entry into the market. Not all countries offer utility models, but many key jurisdictions do, such as Germany, Austria, Brazil, China, Japan, and India. Some allow dual filing, meaning the same invention can be protected simultaneously by both a patent and a utility model. Notably, the European Patent Office, EPO, does not provide utility models, and in the UK and USA utility models are not recognized either. While both IP rights, patents and utility models provide exclusive rights, the strength and enforceability differ. Patents are generally stronger because they undergo prior examination, making them more defensible in court. Utility models are quicker to enforce but are also more vulnerable to invalidation, especially if challenged in court due to their limited examination. Let us now discuss the strategic use of utility models. There are several scenarios where utility models can be used strategically. They enable quick market entry with initial legal protection. They suit low-budget projects or early-stage innovations. They can be combined with a patent application, creating interim protection while awaiting the patent grant. This dual strategy balances speed and long-term strength. How to choose the right IP tool? Choosing between a patent and a utility model depends on several factors. Your time constraints. How quickly do you need protection? Your budget. How much can you invest? The type of your invention. Is it method-based or more structural? And your enforcement goals. Will you assert our rights in court, which means that the validity will be also challenged? To conclude, here are some practical tips. Use a utility model when speed is critical or when working within budget limitations. Consider filing a patent application in parallel for longer-term, more secure protection. Be aware of jurisdictional differences, as the availability and rules surrounding utility models vary by country. Did you like what you learned? Find more in our playlist.